Welcome back, folks. This is Justice Oversight Committee. It is Tuesday, October 25th. We're continuing our meeting. This is our afternoon session, and we do have a full agenda this afternoon. I do want to continue our conversation on the Justice Reinvestment 2 funding, but I would like to start with Ben Nagrowski. I know we've gotten a lot of emails from residents of the town of Newbury based on the court ruling that just occurred. I think it's important for us as a committee to hear from our legal counsel in terms of what our role is as a Justice Oversight Committee. It's my understanding that we have no authority to take any action. I think it's important for us to hear a brief update from our legal counsel in terms of the court ruling, and the court ruling did cite a section of statute that I think we need to be aware of. So then this is, I think, just a very brief, high-level overview of the current situation in the court ruling. So welcome.
Yes, thank you. Ben Nagrowski from the Office of Legislative Counsel. To I guess set the stage a little bit before I go into the update as far as the court's decision regarding the Vermont Permanency Initiative denial, and which involves the siting of the Newbury facility, is just to reiterate that this is just an update for the committee. The committee has no jurisdiction to weigh in or take action on this. This is within the courts, and it's between the parties, subject to the court action. This is really just to provide an overview of a facility that may, once it's up and running, be a part of the committee's authority to provide updates on. So that's what this is attempting to do. So on October 18th, the environmental court handed down a decision that did a few things. It involved the Vermont Permanency Initiative, which is a subsidiary of Beckett, the town of Newbury, AHS, DCF, and concerned citizens for Newbury as well. So what it did essentially is that it denied a motion to dismiss for C4N, which had wanted to dismiss DCF as an interested party. It denied that motion. It issued summary judgment in favor of AHS and VPI, saying that the project is eligible for consideration as a single-family residential use under 24 VSA 4412 G1, and I will go into that statute in a moment. The court also said that there was no dispute of material facts, that the project meets the dimensional standards set forth in Newbury's zoning regulations. What it did, though, is that it provided a 10-day period for parties to object based off of that. And if there was no objection filed, it would make a finding that the project met the dimensional standards of Newbury's zoning regulations. And there were some other questions involved too, but that was really the gist of it. So let's start with the statute that the court opined on, which basically said, so this had to do with a residential care home. So in this subsection, it's listed a residential care home or group home to be operated under state licensing or registration, serving not more than 8 persons who have a disability as defined in 9 VSA section 4501. Shall be considered by right to constitute a permitted single-family residential use of property. This subdivision G does not require a municipality to allow a greater number of residential homes or group homes on a lot than the number of single-family dwellings allowed on the lot. So the issue in this case that the court eventually decided was whether or not the project fit that definition of a residential care facility or group home. And the court found that, yes, the project in Newbury is a group home under the plain meaning of the statute because it will provide an alternative group living arrangement and care to a vulnerable population. It is not a juvenile detention facility, as was argued by the town, and C4N. The statute references residential care home or group home, and the court analyzed both terms in turn. First, the court discussed residential care home, which is defined in 33 VSA section 7102 sub 10. The court found that it is a place other than a licensed foster home that provides room, board, and personal care to 3 or more residents unrelated to the home operator. It analyzed group home. And while group home, the court noted, is undefined in the statutes, it is used throughout Vermont law and in lists that include residential care home, as well as therapeutic community residence, development home, boarding home, assisted living residence, nursing home, correctional facility, or psychiatric unit at a designated hospital. The court used these examples to determine that a group home applies to the facility, and one that's usually located in a residential neighborhood that provide an alternative group living arrangement and care to a vulnerable population like foster children, delinquents, disabled persons, or others with special needs. The court reasoned that this definition is consistent with the legislature's purpose in enacting the statute, as it was to protect residential care facilities and group homes from exclusionary zoning. So that was the court's rationale for finding that the project qualified under that definition. And it looked to other uses of the terms in statute and said that it was in line with the legislature's intent, which was basically to protect these group homes from exclusion from zoning regulations. Basically, where this case stands now is that if no objection is filed by the 28th, there will be a finding on that dimensional standard question, and it could be remanded to the Newberry Zoning Board for reconsideration of the permit. It's also possible that another appeal could be filed to the Supreme Court. So the decision is not final yet, and waiting to see what the parties do with what is before them at the moment.
So at this stage, it is the parties that need to determine how to go forward, be it the town of Newberry or the Agency of Human Services. And for us, in terms of a committee that is not one of the standing committees in the legislature, we are a summer study committee, we have no jurisdiction.
Correct.
Questions? Dick? Are you there?
Yes, if you don't mind, I'd like to just make a brief comment.
Sure.
I totally agree that you and I did a look for another representative, and it's clear that this committee has no jurisdiction over this decision. The decision was made a few years ago to allow the administration. I regret that more wasn't done between Beckett and the community of Newberry to work through some of these issues. I think that's part of the problem. I live in a neighborhood with 3 group homes operated by Beckett, and I've never had a problem with any of them. However, they've never come to the neighborhood and talked to us or done anything in terms of that. So I think that is their issue. For 35 years, I was the executive director of a residential care home for up to 12 delinquent kids. Believe me, in Bennington, when we opened in 1971, we weren't a popular idea with everyone. It takes time. It takes community building. The fact that they actually elected me as their state senator after bringing that program to Bennington, I think says something about the community and their fears and how it all works. But I would be hesitant to do any changes to the law. I think the court was correct in its interpretation of the law. And the legislative intent was to avoid the exclusionary zoning of these programs. And who wants them? It's unfortunate that some of the conversation in Senate Institute.
Well, you froze up, Dick. Oh, you froze up. Maybe you should take yourself off video and,
Okay. Is that better?
keep
Yeah.
talking. Yes.
I just, wanted to mention some of the emails I've gotten from people in Newbury have referenced the conversation in Senate institutions regarding Windsor. I think that was an unfortunate thing. That statements were made about, well, if Windsor doesn't want it, they shouldn't get it. I think that's contrary to the law. The law was designed to make sure that there were places that these young people and other vulnerable populations could be housed. So, frankly, I think it's important that we let the process go through, and I'm supportive of the effort. I do want to just make clear that I think the environmental court interpretation was. Thank you.
Other folks? I did want to offer an opportunity for this committee to get an update on the court decision, to get a walkthrough of the statute that Senator Sears has spoke about, and that to know that the court did look at current statute and made their decision based on current law. And that we, as Justice Oversight Committee, have no authority to act or vote to change that course. And I welcome Senator Sears's remarks. Anything else before we move on? So Ben, while you're in the hot seat, and we have Stephanie, I'd like to come back to the conversation about the 1.9. Got a few minutes. I really want to focus on this, and we've also got to look at our community justice centers and recommendations in terms of any legislative recommendations for that as well. But I really want to try to figure out this 1.9 million plus for out-of-state bids. So first off, I think we reached some agreement on DOC's request for the software for the intelligence layer of 290,000, but I'm not sure. So where are we for the 290,000? Or giving approval for that expenditure so DOC can start possibly going out for bid with an RFP. Teresa.
I feel after listening to testimony and thinking about this over the lunchtime, that I think there is a valid argument to say that this is supportive of reinvestment. And I would be supportive of a motion that enabled them. I would probably actually say up to 300,000 to just round it off, but to pending notification of the appropriate committees as contained in the language to approve.
So
That's where I'm sitting right now.
Putting out a motion?
If you were asking for one, I can put one out. I was just letting you know where I was sitting, but I thought you were asking like, where are we?
Yeah.
So I'm supportive.
Okay. Other folks? Maxine and then Butch.
No, go ahead.
Yeah, I'm just concerned because I know that there are other asks, and so I'm just concerned about doing this one ask without hearing from everybody else. I'm not saying that's not a good idea, not needed, but again, not on money committees, but it just feels a little sort of outside of the entire process. So.
Well, if we approve the up to 300,000, we still have 1.68 million we have to determine as well. which is more than we've ever had in the past, because usually it's around 700,000, 400,000. So I'm just kind of putting out the comparisons. I don't disagree that we would need to hear from other partners. I'm just thinking, there's a lot of layers to this 300,000 or 290. Do we want to get it out the door to allow DOC to get a head start? Do we only have it as one-time money? Not build the base, where the other monies go to building the base? That's what we got to weigh. Butch?
I'm a little hesitant to, it's a unique situation where we have a big pot of money and have a request for a smaller amount for a certain project. And then I was pretty fine with that until you mentioned the request from, that you had this morning.
Network.
$250,000. So that brings to light, do we start parsing that money out or not? And I'm not sure that this committee has the authority to start taking testimony from all of the folks that may have a request, nor the time to do that and do it wisely. So until I have to vote, I'm still on the fence.
Trevor, and then Cheryl, and then Teresa.
I support the request up to 300,000 for this project, appreciating that there's going to be 1.7 million to be decided. In the way I view it, is that I think it would be fine for us to take testimony, but I don't know if there's enough time to take testimony of every player and make a decision within the time frame that we have in this committee. Okay, I think that's a problem. So I think it would be important to hear what those requests might be, because we can carry that information into the start of the legislative session, and the relevant committees of jurisdiction can then weigh in, work through that, and whether that comes to us in appropriations, through BAA or through FY24, then those things can get decided.
If I may, in that process, especially in the House, the process is to involve the standing committees when that comes up. There's a lot of standing committees represented on this committee, and that would be very typical, that it would come to appropriations and then be also ask the standing committees to weigh in on that, if that was the timing that you faced.
Yeah.
Is that in response?
Clarifying, there still be a smaller pot, right?
Oh, 1.6.
Well, it'd be 1.6 million. 1.68 million. And we typically, what we've done with our Justice reinvestment is it goes to transitional housing, domestic violence accountability. Those are really the two big places it's gone to. And then there was some to the offender management system. And then outside of the JR2 line item, there was also 400,000 for the Department of Mental Health for community mental health services. So in that remaining 1.7 million, we could say that gets divided up between what's currently there, which is transitional housing, domestic violence, and then put a section somewhere for community behavioral health. Those are the places right now in our line item for justice reinvestment where the monies go. Does not include the money to the Department of Mental Health for mental health services for folks who are reentering. So the question is, do we expand the entities that are covered under JR2?
So
Cheryl?
you're asking us to make this decision on this money now so that it's expended and money is not left over to be discussed?
That's the question before us as a committee.
And you're suggesting that in order to do that, what we would do is to parcel it out to our partners,
I'm just saying these are our current partners.
partners.
Those are our current partners.
So it seemed to me that our charge was to look at plans that have come before us. And I've only seen one.
Yeah, there's been no plans. And then there was an email
And then
to,
the email that
to
you
me.
received.
yeah, yesterday.
And the department saying that their plan is going to be presented in their budget.
Yeah, let the administration figure out where the money's
Which is-
gonna go. So that's the other layer here. If we only say, I'm only laying this out to help people process. If we say, like what Teresa said, up to 300,000 for the software, for the intelligence layer. If we agree to that, and we have to figure out, is that a one-time? Or is that going to the base? My hunch is it would be one time.
Yeah, we don't have to figure that out. All we're spending is the one-time money right now.
So what is then left, we have to say as a committee, do we leave that up to the administration to propose in their budget adjustment or FY '24 budget where those 1.6 million goes? Or do we make some decisions on where that 1.6 million go?
They have to be sort of generic decisions. We don't have plans. There are no plans that have been presented.
So then that leads into what Maxine brought up, that we need to bring some folks in to testify, to see what their needs are, which then means we do that at our December meeting, because we don't have a meeting in November. And that will be our last meeting before the session starts. So that's the sequence that's before us.
Senator Sears got his hand up.
Dick?
He was talking about the notice timing.
I don't think I can vote, but I do support the motion of up to 300,000. I see this as one time, and I think if we still have the opportunity to increase the base for the domestic violence program or other programs that we wanted to do, and we can discuss that at a later time. But I'm pretty sure I can't vote because of the rules.
Ben?
And also the committee still has to provide notice to those other committees prior to
Right.
any expenditure being approved.
Teresa?
Madam Chair, I'd like to make a motion.
Oh, God.
I'd like to move to authorize the Department of Corrections to utilize up to $300,000 from
Out-of-state bed savings.
out-of-state bed savings for use in the, I don't know what they want to call it,
It's the
intelligence
the
layer
intelligence layer, right?
overlay
Okay.
to their management system, pending notification to the, well, I gotta find the committees here.
It's approach, Sherry institutions.
Appropriations, corrections institutions, and judiciary.
Yeah, and Senate institutions.
Yes.
It's been moved, and is there a second?
Second.
We don't have a clerk, do we?
We have a clerk.
Yeah.
Are you a clerk?
He's a clerk.
You are a clerk?
Well, I-
Okay, you get to go wrong.
Sorry, well, I guess.
It's been moved and seconded that we put up to 300,000 of the out-of-state bed savings to allow DOC to go forward on their intelligence layer. Whatever.
Overlay.
Overlay, their offender management program. And that is it pending approval?
Pending, no, pending
Pending
notification.
notification of the respective committees is laid out in statute. It's been moved and seconded. Is there any further discussion?
So
Yeah,
question comes up, we have a quorum
we have a quorum. There's 6 of us here.
and whenever you're ready, I'll call roll.
I'm ready. Are we ready for the questions? So, Butch, why don't you call the roll?
Okay. Representative Wood,
Yes.
Representative Squirrel,
Yes.
Representative Shaw, I'll vote yes. Representative Grad,
Yes.
Representative Hooker.
Senator.
I'm sorry, Senator.
Yeah.
Okay. My humble apologies. Senator Parent is absent. Senator Lyons is absent. Senator Baruth is absent. Senator Sears cannot vote. So Representative Emmons.
Yes.
So the vote on the motion.
6-0, 6. How many people are missing? 5? 4.
604.
So then would you be able to give notification to the chair? I would have, is it to all members of those committees or just the chairs? How?
It's chairs.
Yeah, it doesn't,
It
Say,
doesn't say, it just says
Right.
committees.
but I would say probably the committee chairs and I think actually probably Julie would probably be the appropriate person to send out as the committee assistant
to
to the various committee chairs. Or,
Julie or Peggy, because
Yeah.
I'm going to be back.
or Julie, not to put you on the spot.
Want that to include a little bit of the amount remaining and that you're continuing to consider.
That's the second question.
Second question, the 1.6. 6.8. What's the committee's wish on this? Do you want to take testimony set up for testimony at our December meeting? From our respective partners, it would be folks from within the transitional housing piece where we'd have to work with DOC on that. Right now, it goes towards domestic violence programming, which is through the network. Those are our 2 partners right now. There was someone put on the table, what's the transition with substance abuse, as we're transitioning folks from an incarcerative setting to a reentry. Where's the handoff there? Should we look at that piece? And the question for the 1.68, are we going to look at just one time or are we building the base? So where are we, folks? There's already been one request that came in from one of our partners. And I have the email here. And there's been, she said, this is from Sarah Robinson from the network. For the past 2 years, funding has been allocated to rebuild their system in terms of community-based domestic violence accountability. The work has included new standards to be created and implemented for programming, improved data collection, and expanded program to better meet the risks and needs of participants. Most recently, the legislature allocated funds to eliminate participant fees for individuals engaged in programming. Currently, a $500,000 investment provides the sole source of funding to the 10 certified domestic violence accountability programs. That's what they've received in FY '23, was $500,000. We have learned a lot about what is needed for this program as we have implemented changes. Most importantly, we have learned that the current level of resources is insufficient to make up for the lost revenues of participant fees. For this reason, we are requesting a $250,000 increase in the Justice Reinvestment allocation to domestic violence accountability programming in FY24. And we plan to formally bring forward this request during the upcoming legislative session. But as you are considering priorities for justice reinvestment funding in FY24, we would ask that you please consider increasing the allocation for this priority. So that was the email that was sent to me yesterday.
I would like to see us do that. I think it's consistent with what we did before. I think if we heard from David Demore, he would talk about, the importance of funding domestic violence programs based on the data that they had gathered.
Mm-hmm.
So, I would like us to include that.
Okay. Thoughts? Butch?
So, I'm sorry, I was doing my clerk stuff, but I was confused as to what fiscal year that they're requesting the funding for. I think they're requesting funding for FY24.
24, because I think the thinking is this is savings from out-of-state beds. It's going to go into the FY24 budget. But what we're hearing from Stephanie, it's part of the FY23 budget.
The money that's available right now is FY23. The decisions about the FY24 base will be made in the budget process. The language that was added to the budget bill intends to sort of force that if you're making investments now with one-time money from savings, to hopefully create the impetus to make those base investments again in 24, and then they're embedded in the base, and you're not talking about this, is it in or out the base? You put it in, but that decision will be made when you pass an FY24 budget, and enact a 24 budget.
So with that, are we better off to language in this request at the next meeting for inclusion, recommending that request be included in the FY24
Budget.
program, base budget? Did I get that right?
So that would be a request or a statement from this committee saying we support the inclusion of increased funding in the base in FY24. It doesn't speak to the remaining money on the table in FY23. Is I'm understanding what you're saying?
Mm-hmm.
But if we decide to say, let's use part of that 1.6 million for the 250 for the network and have that as part of their base, that money becomes available in FY23.
You could take an action.
And it's built into the FY24 budget, supposedly.
The intent is there. The intent is there. The actual final action remains to be seen.
At least we weighed in and said, yes, that's our intent.
So I was a little bit unclear. I know from lunchtime conversation that there was some money built into the FY23 budget to help remove.
There was, I forgot how much we added in. They have a total of $500,000, and I know we went up a little bit from what the initial request was to clear those fees.
There was 200,000, we added 300.
300?
So, and so I was unclear about the 250 that they're asking for now. Is that for this year?
What they want is for FY24.
Okay.
We're requesting 250,000 increase in the justice reinvestment allocation in FY24. I think, I can't speak for them, but I think what they're thinking is that this 1.98 million is going to be appropriated in FY24.
Sure.
But it
Okay.
isn't, it's within FY23.
So that would be a statement from us in terms of recommending that, not for use of the one-time money that we have right now.
Well, what I'm hearing is we would use 250 of the remaining 1.68 million for for this.
They're not asking for it in 23 though. They're asking for it in
It
24.
would be 23.
It would be 23, which then says, Appropriations Committee, you need to, your base budget has just been increased by 250,000 for FY '24. At this line.
I understand that that's what the intent would show. I'm just saying that they didn't ask for more money in 23.
I think
Other than what
because
they
there
got.
was
No, I
confusion.
agree with you, but
Yeah.
one-time money, any allocation we make,
Is
request is FY '23 money. That's just the nature of
Yeah,
what that
Right.
money is. I would, since it's a change from what they requested, because maybe they didn't know this was an option.
Right.
That's, you might want to get clarity about whether or not they're asking for 23 money or not.
The opportunity to come to our next meeting, make the case for it to be an FY '23, and we can act on that.
right.
I mean, I'm supportive of it. I just want to act on what the request is, and the request wasn't for the decision that we were making about this
And
one.
I don't want to usurp the authority of the Appropriations Committee.
Well, and
I do.
but that's, on that point, Representative Shaw, on that point, Representative Shaw, I mean, the only authority that this committee has is just to approve. There's nothing to say that anything that is not approved there can be a recommendation. There's also nothing that says you can't make a recommendation, but I'm just saying the specific authority is only to approve and then notify those other committees. So just to keep that in mind.
And
We've already approved 300,000.
right.
We already approved 300,000. So the question is, what do we do for the approval of the remaining 1.68 million?
And if the 250,000 is for
FY
23,
'23, it's part of that
Then
1.68
that's-
million. So,
that has to be clarified.
Trevor,
Can we make two decisions here, right? One is the one we just made for the 300,000. Come back at the next meeting and have another decision about to have a use.
the 1.68,
1.6.
that's what I'm trying
How do
to,
we decide to do that? Right? Maybe it's 250 to Vermont Network, and the balance just goes into the new session for discussion amongst relevant committees, right?
would do
And
that.
to me, there's a couple of different ways you can approach that, but we can do that in the next meeting.
You could,
And we could ask our partners to come in and testify,
Well, yes.
like the network, to clarify the 250. And then who are our partners in the transitional housing? Is that you folks, DOC? I mean, how do we get our handle around our transitional housing piece?
There's a lot of groups on the transitional housing now. Pathways operates in many counties through a contract with DOC. And are looking to expand. And I think that some of the, that we spoke about earlier, some of the programs like Serenity House and et cetera, we're using funds for transition out of prison housing.
And then, of course, we have a big chunk, it's also going to our restorative justice, CJCs.
Right.
kettle of fish, Madam Chair.
Kettle of fish, I'm trying to figure out for the agenda for next December, who to invite.
I think unless we heard from all of those folks, we'd be criticized for hearing from just one group.
Right. So where are we? The network is easy. The CJCs are kind of easy. I don't know how to deal with the transitional housing. I think Dick has a good point. You can't just say, well, we'll have pathways in and not some of the other providers. And then we wanted to look at the substance use.
I don't know if this is a good suggestion or not, but when you're looking at that universe of partners and you're talking about FY '23 money, if there's immediate FY '23 need that you need to hear about in December, that might be important versus waiting until you weigh in. The administration would go first on the recommendation, but they're not the final word. You would be the final word as the legislature on the use of the '23 money in the budget adjustment process. And so when you're thinking about the time constraint you're under in terms of December, if you are trying to figure out who to ask in and what you want to hear from them, I think you would want to hear immediate 23 needs because the things that aren't immediate, you have more time in the legislative session to address.
So I'm just wondering in terms of the timing, if there could be an email or correspondence sent out from this committee to our partners to weigh in terms of what Stephanie just said, in terms of their immediate need in
Right now in FY '23.
and what their need would be for FY '24. And we, look at DOC, can we get a list of our transitional housing partners out there? I know it's Pathways, but there's others. Can we get a list of that where our Justice Reinvestment $2 go to? Can you do that or not?
Well, what we have, Sharon, is what we call public listing, which I'd be happy to provide the link to. It's on our public website of all the DOC funded transitional housing programs. Now, those programs derive their base funding from general fund that predates Justice Reinvestment, and their ongoing operations are not in fact predicated on Justice Reinvestment savings per se. So while we're happy to provide you the link to the list of our partners, I'm not sure if that's exactly what you're looking for in this exercise.
I'm looking that we don't single out one entity. Dick?
But, when I asked about what happened to the funding for Justice Reinvestment 1, I was told it was in transitional housing. So you can't have it both ways, frankly. You're trying to say it's part of the budget, but you took all the money from Justice Reinvestment, not you, Derek, but the administration and the legislature took all the money from Justice Reinvestment 1. And then when I said, where does the money go? They said transitional housing. So I do think there's a connection.
Well, where do we go here, folks? Trying to get us to move off the dime.
Well, it seems like we either extend an invitation to all the parties that to anybody, frankly, who we can think of being an appropriate invitee. Or we punt and say, we're making this decision and we're going to let the appropriations process make the rest, which is what DOC wants to do. They want to come in January to budget adjustment with a recommendation. That was the commissioner's sense.
How does the committee feel on that?
Well, I wasn't particularly thrilled about it, to be perfectly honest. And I would be okay with, if we could, I think we need to be inclusive. So, we can't sort of like single out one just because the department gave us a proposal. Other people didn't maybe understand that they could also contact us, or we're waiting for the department to present their needs, which is, So anyways, I think we need to either like be all inclusive or punt it to the appropriations process, which I don't really like, to be honest with you.
So what if we sent out a correspondence to the network, to all the partners we do see on the transitional housing? And I don't know who would be for substance abuse partners? Joining points?
Yeah, we can find out who the appropriate people would
If we
be.
just sent out a correspondence
And CJCs.
and CJCs to submit back to us electronically with their immediate FY '23 needs, meet the goals of 2002, and their needs for FY '24. And to have that back to us by the end of November. So that at least it gives us a head start on our December meeting in case folks want to come before us to testify.
So I just have a question about
I'm just trying to
why would we
expedite
do the
this.
24 part? Is that just so that we might make a recommendation to the appropriations? Because that's not really our job to do the 24.
If we don't make a decision on the 1.6 million, I'm looking at Stephanie, wouldn't that then, what heard the Commission of Corrections saying, that they would like us to hold off on that so that it can be part of the governor's recommended budget for FY '24?
They did say that.
They did or did not?
I heard that the same way. Benefit of asking for the information and having it, you may decide not as this committee to take an action in December, but then you have information as you go into the budget process, the BAA, the FY '23 adjustment. And you have their request for '24 in relief to whatever the administration puts on the table for '24. So it's information for you. It may not be actionable for this committee, but it doesn't, from my point of view, it's no harm to ask for that information. They might not have a full picture themselves yet to provide it, but it doesn't, it gives you a sort of another benchmark of we don't have immediate '23 need, but we see our '24 growing. It gives you the landscape.
I guess it could help us in whatever recommendation that we make to appropriations.
And it would help our colleagues, that they know they got a place to go for some backup.
The policy committees, yeah.
So are you talking when you send out the correspondence? This is advisory for the committee? Or this committee?
Yes,
That we can advise appropriations.
or advise ourselves in terms of,
I'm afraid we're going to we're either going to make everybody angry or please nobody. Or
so then the other way is what we've already done, which is approve up to 300,000 for a DOC. And then the remaining 1.68 still on the table that we can be silent on.
it would be dealt with at BAA.
Could be dealt with in BAA with our appropriations committee, or the administration would propose something in BAA or FY '24 for it.
Yeah.
So where are we? Have we circled back to that? That's what I'm picking up. Maxine?
I just want to restate if we go that way, my initial concern about approving money for one entity.
And not another.
That was outside of, the original and not for the other. So I'm just throwing that out there.
So what?
That's why I think we should give the other folks an opportunity the knowledge and the opportunity to, sorry.
No, that's.
I think they should have the opportunity to present their case at our December meeting.
But,
Then otherwise we just have shown preference.
Time's going to run out on us. Teresa. The time's just going to run out on the committee to do anything because somebody comes in with a request and we have one question that they can't answer, then we don't have another meeting to go to.
But you have the groundwork in place for the budget adjustment process.
Yeah.
We've done information gathering for.
Yeah, that's the.
Trevor?
Yeah, I just want to go back to the point that Stephanie reiterated. I mean, it does no harm for us to bring these stakeholders in, have a conversation. I agree, we don't have time, I think, to listen to that. And for them to respond to questions and then make a decision in this committee that it can inform the process going forward for the appropriations process and the BAA and anything that might flow into
Or you might
section
find,
C of the FY
you might find that there is
24.
something critical,
Yeah.
immediate in '23 that you can act on. I don't know that, but you may find that out if you're asking for that.
So are we back where I was just trying to expedite this by having having electronics correspondence sent out in the next few weeks, next week or two, to our partners, whoever they may be, and have them respond back to us by Thanksgiving about are there any immediate FY '23 needs? And What are your FY '24 needs? Are we back at that point? So we then have that information for a December meeting, where maybe we don't have to bring all the folks in, but at least they've responded electronically to our inquiry. Trevor, and then Maxine, do you have your hand up, Trevor?
Yeah, I just want to go back to Butch's concern about putting out a request for people to ask for money, for funding, and then disappointing all, or whatever the case may be. So I think the wording of that communication is going to be important, that we're looking for information, and we will not be making the decision as a committee. Maybe we decided we will not make decisions based on that funding at that meeting, because we might know what we want to do with a particular entity, right? But we may not know about all of them. Now we want to divvy up that money. That's my thought, that just make sure we get the wording right in that communication.
But in that case, doesn't it then assume that the money's going to go forward? You know, we've already appropriated or approved the 300,000, but the rest of it is going to go forward. Having them put out their requests for our information is, I mean, what's
Well,
that?
we carry those requests into the session, right? Because the administration will, DOC will come in with a recommendation for the I'll use 1.7 million with the AA.
Mm-hmm.
I guarantee you, we're not going to agree with that on some level, right? And we'll turn to the committees of jurisdiction to weigh in on those requests. And then those same committees of jurisdiction can take on additional requests for funding within that structure. And then that will flow back to the appropriations committee. And then we'll make a decision about that process.
And when you make the decision about that, where the money goes, you look at the respective committees.
Yeah. So I don't see any harm in doing what I think I'm proposing here. So a leg up on understanding what the needs are.
So,
But I think the wording of that communication is.
so it's information gathering. Ben?
Yeah, the only thing there are a couple things that stick out to me that I think the committee needs to consider is that, one, when Derek referenced that not all the transitional housing partners are funded through JRI funds, I mean, ultimately, that's what this money is tied to, is that it has to be community-based services tied to justice reinvestment initiatives. So I think that's something to be really cognizant of when the committee is reaching out to certain partners to ensure that they have access to that money to begin with. And secondly, again, sort of like recommendations and information gathering, while there's merit to that, again, there's sort of the role that the legislature plays and the delegation of authority that this committee has when compared to the executive branch and their ability to propose a budget and the adjustments to the budget. So, you know, I just want the committee to be aware of sort of those boundaries and not crossing them unnecessarily or unintentionally.
So I wonder if we take a whole step back, we've got 1.68 million, and not worry about giving an approval to where those dollars go, but have a correspondence to our respective committees, appropriations, judiciary, institutions, that we would like further dive into these programs, either transitional housing, the network, looking at substance abuse, transition for folks from an incarcerated setting to reentry, where's the warm handoff. We're not going to give approval at this point to dispersing the remaining 1.6 million. But we want the respective committees, standing committees, to do a little deeper dive into where our justice reinvestment dollars should be invested in. I wonder if that's the way that we can.
So that correspondence would go to the same committees that are being notified about the 290?
Yeah, the judiciary committees, institutions committees.
And would this be part of our final summary of what this committee has done?
Well, it'll be part of the approval
And notice.
of the out-of-state bids plan for reinvestment of those dollars. We need more clarification in terms of our community partners and how that JR2 money is being spent, their immediate need for FY23 and their needs for FY24. I wonder if that's the way to approach it.
I just have a clarifying question for Ben and or Stephanie is, with regard to the transitional housing and for those programs that currently receive justice reinvestment funds. Because I mean, the way I read the paragraph in terms of simple language, it says for community-based service programs. It doesn't say for community-based service programs that currently receive justice reinvestment funds.
Yeah, I actually don't have the language right in front of me right now, but I think that there was the addition of, forgive me, that is tied to adjustment reinvestment initiatives or.
But it's not exclusive to the ones that are getting funding at this moment. There could be
Right.
additional.
That's what I'm saying. And I thought Ben was trying to limit that to only ones that are getting funding now. And I don't read it that way.
Okay.
There's nothing in the language that does that limitation.
Right.
And maybe that's what we can say. We need further clarification on
Seems clear.
community-based service programs.
I think they left it open. I think they left it broad on purpose
Right.
to not be necessarily tied to only those services that we currently do. I mean, there could be something new that comes along, or it could be a mixed provider.
So we've got to move on here because we've got some other.
And just to clarify, so the language is to provide additional funding to community-based service programs in support of justice reinvestment 2 initiatives. Funds may only be expended on community-based programs upon approval of justice oversight. I mean, I think that you could read a restriction though, that the additional funding to community-based programs is qualified by in support of the justice reinvestment 2 initiatives. So and again, just opening it up to entities that may receive community-based program or community-based funding that don't receive justice reinvestment, it just might get convoluted and create, and unintentionally create a problem.
I think I'm just going to respectfully disagree. I mean, I think that it definitely, the overriding thing is it has to be in support of justice reinvestment. I mean, that's the whole point. It doesn't mean just those people who are getting current funding under justice reinvestment. I mean, anything that we propose has to be related to justice reinvestment. I mean, that's why this is under that category. But anyways, you want to move on, Madam Chair?
I do want to move
Yes,
on, but
sorry.
I think
I'll
that
be
could be
quiet from
part
now
of
on.
our approval process, that we need better clarification in terms of our partners and what they're providing to address our justice reinvestment initiatives.
I think you might want a definition of justice reinvestment 2 initiatives.
Right.
Is existing funding part of the definition, or, you know, I think that's what you're stuck on, is that one.
Maxine?
And I'm going to go back to, what was David Demora asked to speak to us about?
It was data collection, and how is that, I know Dick has wanted this to be part about justice reinvestment 2 and the data collection to make sure that our investments are getting the outcomes that we want, and how we collect that data for that. And what is the data showing if we're meeting our outcomes that we wanted?
Yeah.
So, yeah, so I think there's a hold right now on that 1.6. And maybe Ben and I can work a little bit in terms of what language we could make as I don't want to say a recommendation, but a request of our standing committees to look a little deeper in clarifying what they mean by community-based. On my glasses so I could really make sure I get the language, community-based service programs and their work in terms of applying it towards our justice reinvestment initiatives and what those initiatives, the definition of JR2. makes sense? And then we can talk about this more in December. And we might be a little clearer on the 1.6.
Sounds good to me.
So I know we've got to talk about justice centers. Also, I have the Secretary of the Agency of Human Services who's data placements of violent juveniles. Both of them are long conversations. I don't know what either one of your schedules are. Which one has a little bit more flexibility? You're available this afternoon, and so I'd like to skip over you folks, put you at the end, possible, so that we can go update on the placement of violent juveniles with the Secretary of the Agency of Human Services. This is a conversation that we started last month in terms of, it was brought to our attention by the state's attorney in Bennington County about situations of violent juveniles who really do need a placement. And just for folks who may be looking in on YouTube that have an interest in the court ruling that just occurred, our conversation last month was prior to the court ruling for the Newberry situation. This item here is a follow-up of our conversation last September, and trying to find a placement for our violent juveniles. And it just so happened that the court decision came last week, but we already had this on the schedule. So it's, how are we going to address this statewide as a state issue? And we did ask the Agency of Human Services. We had both the Commissioner of DCF and the Commissioner of Corrections at the table at our last meeting. And we asked them to come back to us with a plan on how we move forward with the placement of our violent juveniles as we go forward. There is also language in legislation that was passed that required the Agency of Human Services to come back to the legislature with a report at the end of this year in time for next session on a plan for placements of our juveniles that, number one, would normally have been held at the Woodside facility, but also for folks on youthful offender raise the age status. So we did include language in that in our legislative session last session. And I know the administration's been working on that report as well. So with that being said, I'm going to turn it over to Secretary Samuelson. And are you still there with us? I can see you. So welcome. And if you could just introduce yourself, Secretary, I'd appreciate it.
Yes, good afternoon, everyone. Thank you for having me here today. I'm Jenny Samuelson. I'm the secretary here at the Agency of Human Services. And as was brought up, we'll be talking this afternoon about placement of youth across the state. Before I get started, I wanted to take a moment. This weekend, I had a chance to travel down to one of the programs that serves our youth in the state, often who are coming into programs with significant needs, CL down in the Bennington area. I wanted to recognize that they were having their 50th year anniversary, and that Senator Sears was honored there for his contributions to the system of care that we're going to talk about today, with both kicking off the CL program, which is still an integral part of the youth system. And so just wanted to recognize him for his years of service there, and for that program and what it really means in our means to youth today.
Thank you, ma'am.
As we look at the work in front of us, I think what you will see is that it reflects the past year's legislative work in our juvenile justice system and in the raise the age policy. And I want to recognize that as we go through this today, that we all share the same goals, which are working with youth with significant challenges to achieve their potential. It's the responsibility of AHS to our staff, but also to the youth that we serve. And so I want to take a moment to commend the work of the district staff and the direct care staff and family services. As was discussed last time, that compared to the pre-pandemic level in our system, that 50% of the youth beds were closed throughout the pandemic, which has caused some of the pinch points that we are seeing in the system of care. That through their work, they've built back up some of those programs, including some of the programs that will serve the youth that we're talking about today who have higher acuity needs than we've potentially seen in the past. That includes an additional bed at the Wyndham Sheriff's Office that will be serving, that is able and capable to serve youth for 24 to 48 hours as we work to find a placement for them. It includes the Brattleboro Retreat, having stronger policies around accepting youth, many of whom are the youth that we're talking about today, and strengthening other programs throughout the system with financial and staffing supports like NFI. Because of that, we are seeing the fruits of our labor that in the last 3 to 4 weeks, we have not seen a youth come into our programs with the acute needs, like the individuals who have perpetrated violence acts, not having a space to go for placement because of programs like the Wyndham Brattleboro Retreat, SEAL, and the Vermont School for Girls. I want to recognize that the staff stepped up and came to the plate during the pandemic and have really filled in for direct care providers as the system came down, but that it's time for us to move forward with more sustainable plans as we go forward. Per the discussion last time that when folks met, the goal was really to come back with what is our plan. As you stated clearly, that before you made that request, the Newberry facility had not achieved approval. And so that will be a discussion today. But really the agency and the Department for Children and Families has a 3-part plan. The first part is a secure residential treatment program to continue to fill out the gaps in our system. The second is a short-term treatment focused juvenile facility. And the last is a long-term treatment focused juvenile facility. So to get started, to go through each of these, again, the first of those 3 options is the secure residential treatment program. That's been identified and cited in Newberry, Vermont. And as was stated previously, it had been in environmental court, and environmental court ruled in favor of the state. I want to recognize that the program in Newberry is a residential treatment program and not a detention center. And I know many of the legislators here are continuing to get feedback from the local community who we are committed to working with. The goal is to provide treatment and support for youth. And unlike a detention center, the provider makes the decisions about who is admitted, and that we trust that Beckett, who has a long history in this area, knows their programs and the limitations of who they can serve and serve safely. I also want to point out that this facility serves six youth and specifically serves boys only. In many cases, it's like the programs that we've seen that have been successful in Bennington, including the Vermont School for Girls in SEAL, who had some initial concerns from their communities, but over time and history have proven to be quite effective. We know we have work to do with the Newberry community to understand what the program is and isn't, and we are open to continuing to have discussions about the design elements that have been incorporated into the Newberry facility to alleviate the concerns of the community and propose community investments to also address their concerns. Again, that's option, that is part 1 of our 3-part plan. And there are some additional things I want to lay out. Specifically, as I lay out the temporary solution, I know that you've heard plans in the past that have fallen through. I want to assure you that we're in a different place now. And then in many ways, I'm as frustrated as you were last time you met that we haven't found a permanent solution. One reason is that we've been searching for a long-term solution as a starting place, and the complexity of finding and developing a permanent solution poses a long-term challenge. What you'll be hearing today is that we've broken this out into a short-term and long-term pathways. The first is a temporary secure facility that will be stood up in a matter of months and is being administered by a treatment provider. And the treatment provider is really important. They have an expertise that we don't have in-house, and they have a broad set of providers that they can, the broad set of staff that they can move through their continuum of care, so that those at the highest acuity have, as we saw with CEOL this weekend, 20 and 30 years of experience that have been able to be cultivated by these organizations, something that we can't do when we're only talking about a small program of 6 or so beds. We're also looking for a permanent secure placement facility with a treatment provider as well, but we'll take the time to identify the place and a community that will be accepting of this secure facility. Related to the temporary facility, we are actively looking into properties now. We're going back and revisiting and have been considering properties that we've looked at. We've had a treatment provider. I was hopeful that today I would be able to announce where that would be, but we've had a treatment providers on site to ensure that what's being proposed can be adapted to a therapeutic program. And in those conversations, they proposed a few design modifications that we need to consider before we formally begin to move forward. We believe that we will have a viable option to discuss with legislators within a week to weeks. So this isn't a month-long process, and the modifications and design principles are not long-term and shouldn't slow down the process of getting a facility up and going in the short term, but simply are important so that we can calibrate the pros and the cons of different options on the table. What's different now is that it's not just DCF that's looking at this, but the full weight of the Agency of Human Services, as well as other agencies in state government who are moving this forward. It's been identified by VGS and others as a critical project that needs to be moved forward in a matter of months. In addition to the temporary facility where we'll be siting on likely a property owned by the state, we are also looking at a long-term option. This will be a therapeutic juvenile facility, and we are actively going to begin working to identify properties and improve on the process that we had with Newberry, really to engage the communities in the decision-making, assessing their interests in this long-term option. In the meantime, as we prepare for these options to come online, we have the center in Wyndham, which can house an individual who comes into custody with it for a 24 to 48-hour period. We also have strengthened our relationships between DOC and DCF, which have a proven track record over the last months of being able to take very violent youth who are escalated and are able to stabilize them as we look for an appropriate placement for them with a therapeutic service environment. In this case, this means really wraparound services that are provided both by DOC and by DCF. And we believe that doing this on an ad hoc basis is best. What we've seen is no more than 7 youth come into the program over the last 2 years. And now we feel better prepared than ever to be able to respond. I want to take a moment again to reflect on the work done by the DCF staff. It's relieved the pressure on the youth system. It's moving forward to a stronger system through CEOL and other partners, and it's relieving the pressure on the staff that we've seen accelerate over the last 2 years. The Deputy Secretary here at the Agency of Human Services over the last month has been going out to all of the districts and is committed to continuing to hear the staff's concerns and ideas for the future. And we look forward to working together across the agency to set a course and a plan. I want to reinforce the agency is committed to both our youth and our staff and are looking at their well-being and outcomes. Our focus really is on providing therapeutic care. We've seen time and time again that strengthening our partnership with experts in the field, that through that pathway where they have highly trained staff, that we're able to provide stabilization and ongoing treatment for youth, that we're able to achieve better outcomes. Examples of these include long-term partnerships that we've had throughout the state with organizations like Beckett and CL. These examples show what we're able to accomplish through partnership as they bring programs on board that are with their therapeutic expertise that gives Vermont youth an opportunity to turn their lives around. And we believe that this pathway of looking at this three-part, a therapeutic residence in Newberry, a short-term facility working with a therapeutic provider, and a long-term option also working with a therapeutic provider is our best option for our youth and our staff. So I want to take a moment to pause there and solicit questions and feedback. But again, we have in the very short term right now, the Wyndham Center and our correctional facilities and our other providers that have come back online who are prepared now to work with our youth, as well as working forward in the next month to a property that we believe will be a medium-term solution, temporary solution, while we look for a longer-term option.
So, Secretary, I want to thank you for it seems like the Secretary of the agency is now more involved than you have been than there has been in the past. And I want to thank you for that involvement, that it's coming from the Secretary's office and not being left to the individual commissioners within your agency. And that being said, I'd be curious in terms of the permanent facility part, the last part of your three-part plan, you were talking about wraparound services and that would be coming from both DCF as well as DOC. Could you expand that a little bit? Could you explain that a little bit more?
Yeah, I want to be clear that in the very short term, we are using wraparound services in DOC facilities that include us using the DCF facility as a placement and DCF and their providers providing wraparound services for youth. We've seen this over the last couple of months. In the long term, though, we acknowledge that identifying a facility with a therapeutic provider that is not state staffed is likely in our best interest. What we know is that providers, providers that we've worked with in the community have training opportunities for their staff. They have usually a continuum of care. If they're working at this high end, they either are working at this high end in other states or have a continuum of care with residential placements. They are better and more capable than we are as a state to provide the wraparound supports that these youth need in smaller programs. So really, not a state-run facility, but a facility that is in partnership with the state and a therapeutic provider, but that has a no eject and no reject policy.
Questions? Teresa?
Secretary, what kind of capacity are you looking at so you've outlined 3 different levels. What's your total capacity that you're looking at among all those 3 levels?
Yeah, the buildings that we are looking at now really are capacity of 6 to 8 youth. That's what we've seen. That we've had less than that throughout the last couple of years. Newberry, which is therapeutic, will have 6 beds. The thing to point out is that those 6 beds are are 6 beds only for male use. And so the adding additional beds will give us the opportunity to serve both genders, as well as any additional overflow. What we know is that we've got, a common question is that going to be too many beds? What we know is we've got many youths who could benefit from the Newberry facility that we currently have out of state, who are in therapy with therapeutic providers out of state. So no, we don't think that would be overvetted, but that's what we're currently looking at.
So I have a question of clarification, and I think it's just how we define the terms. When you use short-term treatment program and long-term treatment program,
Yes.
are you referring to the length of time someone would stay in the program? Or are you referring to short-term treatment program, you're looking at a temporary solution before you get to the permanent solution? So I want to be clear on that terminology of short-term treatment and long-term treatment. You're not talking about the treatment time for the juvenile who's there. You're talking about a temporary situation of 6 to 8 beds somewhere, while you're also looking to replace that temporary facility with a permanent facility someplace.
Yes, thank you for the clarification. I wasn't clear in my terminology. That's absolutely correct. What we are looking for is that at this, over time, the last year, where folks have been looking for a facility that could serve Vermont for the long term. And what we've come to recognize is that is challenging to site and place. So we are going to pursue a temporary facility that will eventually be replaced by that long-term option. So thank you for the clarification. It again, while it will be served by a treatment provider, we're not talking about the length of stay. We're talking about the ability to spin up and meet the needs now, and then have a long-term system of care.
Okay, great, thank you. Dick?
Yeah, you brought up an important point, Madam Chair. And the problem, one of the major problems is we have the short-term programs, for example, in Bennington, and they're able to handle kids for a couple of weeks to stabilize them. What happens is frequently there's no place for that kid to go that's appropriate. And the kid gets frustrated and sometimes acts out violently, ends up in the local hospital emergency room or detained by the police or whatever, and including social workers. And I think that's part of the problem. What's lacking is that opportunity. And the longer a kid stays in what's supposed to be a short-term program, the more frustrated they get. But specifically, some of them end up with adult charges because the violence is so serious that their charges are adults. So that's another part of the problem. I think having long-term solutions available will help to improve things in the short-term programs, believe it or not.
So, Secretary, is this connected to the language that we put in last session, that the administration comes back to us with a plan on how we move forward with the placement of violent juveniles?
I think you will find this reflected in that plan as we prepare and present it. Today is really in response to the important questions that this committee asked last time to both DOC and to DCF.
Okay, great. Any further questions for the Secretary? Committee. Okay. You might want to stay on. We do have VSCA that wanted to testify on this. So Steve, why don't you come on up? It's your day.
Yeah, definitely. Thank you very much. Let me start by just saying, first of all, I'd also like to pay tribute to Senator Sears and his decades-long experience and commitment to the youth in the state in Bennington and to all of you as well.
Thank you.
Let me just start by saying that since the closure of Woodside, which is the real cause of the problem here, it's not COVID, which is used often as a crutch in state government to blame the failure of the administration. It was this, since the closure of Woodside, this has been an unmitigated disaster. This is a huge management failure. And unfortunately, I'm very pleased to see the secretaries involved, finally, in this discussion. We've never heard from the secretary on this issue. Our members have been really paying the price for the decision to close Woodside. Rather than reform Woodside, rebuild Woodside, and get it back to its nationally recognized program, it was completely abandoned in favor of a private provider with promises of great expense to the taxpayers. So I just want to put that on the record, because when I say that our members have paid the price, and I'm glad to hear the secretary reference the commitment of the staff, it's not just that they had to work unbelievable amounts of overtime to keep this system going. It's that they have been asked to do things that no human being should be asked to do. They've been asked to really take on the job of correctional officers and law enforcement officers, to sit with youth not much younger than many of them, who have exhibited extreme violence, who have had some accusations of using firearms in the behavior that got them involved in this whole system to begin with. So I just want to say that for the record, because I know it's sort of water under the bridge at this point, but the stress level and the physical threat to the family service workers is inexcusable, should never have occurred, and is ongoing. And I want to stress that because throughout the discussions with the Department of Children and Families, and we have them every month with the commissioner or the deputy commissioner, the solution to this problem is always 2 weeks away. That was almost a year ago. The facility in Wyndham, 2 weeks away. The temporary facility, 2 weeks away. We're looking at a property, it's 2 weeks away. Our members are tired of hearing it's 2 weeks away. Their lives are in jeopardy. They're exhausted and they're tired, and they're really, frankly, hoping that the legislature will hold this administration's feet to the fire on their commitment to get this facility up and running. And I just say it with a sense of urgency, because we're not just talking about, well, it's really hard to find a place to put a youth. We're talking about a situation where somebody is going to be seriously hurt or killed because they were asked to do something that they should never have been asked to do. I took a phone call from a social worker just the other day, a young social worker who called because she was concerned about something she was being asked to do. And basically the message from the management to her was, you're not a good social worker unless you do this thing that you think is dangerous. That should never be the message coming from the management, ever. So I just want to stress the urgency of the problem here. And you know, our members, while we had hoped that Woodside would, that the legislature would have adopted the plan that was put forward by our members to reform Woodside, after management really, I think, exhibited, made what was an award-winning program a problematic program from the perspective of the legislature. I think that issue is really not one we're going to fight today, but one that I think we want to stress for future reference, that before you close a facility, make sure you have a new one ready to go. And not just because it's inconvenient, but because the lives of the people in family services matter. And they should not be exposed to the kind of violence that they've been exposed to. Yeah, I think the other issue that our folks in family services have raised is, when I'm glad to hear some clarification from the administration about what this facility in Newbury is and what they're hoping to do with additional facilities. Our members do believe there has to be a locked facility. We think that it's just naive to believe that we can treat these youth without some facility that is secure, not just with staff. Obviously, some facilities at some point are staff secure facilities are appropriate. They also believe that there is a need for, I don't know if you call them detention beds, but some secure facility where the youth could be de-escalated and prepared for the course of their therapeutic interventions that might come down the road. So that is something that they really wanted to emphasize. And I think it's important that this committee, that the legislature in the upcoming session continue to engage the secretary on this question, to engage the governor on this question, and to not allow the administration to continue to just promise that they have a solution in sight. At some point, we have to have actual beds opened. And it's been a long stretch of promises. So we really do have to, I think, find some way to hold their feet to their fire on that issue. We'll always disagree that private providers are better than state providers and that the state can't train employees to do the work that needs to be done. Woodside was a nationally recognized, award-winning facility before we had 4 managers in 2 years. It's a common theme today. Lots of managers turning over and over again. And it is, from our perspective, Woodside is a management failure, not a failure of the frontline staff. What's happening in DCF today, while our members are paying the price, is a management failure. And so we ask you to hold them accountable and to keep them on the path of getting this solution in place quickly, because we don't have a lot of time. Thank you.
Thank you, Steve. Questions? Thank you.
Thank you very much.
Yes, it's going to keep unfolding.
Yes, I think it will.
Anything else for the Secretary of the Agency of Human Services on this while she's still with us? So I would assume by the time we meet in December, we will have more direction from the administration in terms of where you're headed for a temporary facility and then where you're headed for the permanent facility. Is that correct to say, Secretary?
Yes, that is correct to say. We should have a clear path on the temporary facility and at least an outline of the steps that we're taking on the permanent facility.
Is that something the committee would like to schedule in to hear that at our next meeting in December?
Yes, please.
Okay. So our next meeting is, I forgot what date it was. Is it the 12th? Of December? It's, I believe, on a Monday. So let's schedule that in for that. Anything else? Thank you, Secretary, for making the time today. We appreciate it. And the conversation will continue.
It will. I look forward to it. Thank you for having me.
Okay, thank you. And thank you, Steve, for coming in as well.
Thank you.
For that. Okay, let's go to our justice centers. And Willa and Joe have been patient. We need to, as a committee, really figure out where we are in terms of what recommendations we're going to make. And I don't know if, Ben, you want to come back up to the hot seat? We have heard a lot of testimony on our justice centers. And we do need to make some kind of recommendations on how we move forward with our community justice centers. So, oh, you can give us here. I'm trying to find.
Right.
No, I'm trying to find our packet here for this too. Part of the budget bill that we would look at Vermont's restorative justice programming and services, would include the administration and services, which we really didn't, court diversion programs, and the balance and restorative justice initiatives in our community justice centers. We need to consider strategies for ensuring geographic consistency and equity. And we need to recommend any changes to streamline the restorative justice programming and services. And we can submit any proposed legislation which results from what we've seen. So, what strategies have we considered? And what changes are we going to recommend? So, Ben, I don't know if you can summarize at all anything that we've heard or our direction.
Well, I'll do my best to do that. Ben Novogrodsky from the Office of Legislative Counsel. There's been a lot of testimony from the Department of Corrections, DCF, the AG's office, and then directors from community justice centers, among others, about status of community justice centers in the state, restorative justice initiatives and programming, and how it's all funded. I think one suggestion, and this really came more recently, was related to the geographic consistency between of prosecutors from county to county. And there was a suggestion from some of the witnesses, and I think discussion amongst this committee about mandating maybe a presumption of referrals to essentially limit the discretion of prosecutors in certain circumstances to refer certain types of offenses right out of the gate to these centers and programs. That appeared to be really, I think, the one almost consensus gaining suggestion amongst the providers themselves that this committee heard. That would require a change to the law when it comes to prosecutorial discretion, also to the various titles that touch on restorative justice programming, Title 24, Title 3, Title 33, to essentially shore up that there would be a presumption of a referral pending some sort of overarching need that maybe would that would override the presumption. There was also suggestions about, or at least discussion about potentially streamlining funding. I wouldn't venture to say that there have been suggestions on how to actually do that yet. Currently, it's done primarily through a grant-based program through the I'm going to call the big three agencies, DCF, DOC, and the AG's office, that provide grants to the providers that often administer these programs at a physical location that's commonly referred to as a community justice center. But really, it's really at the committee's discretion at this point to discuss what there could be for potential solutions here. But I again, to kind of summarize, I think that really the one piece that there was a consensus on I'm not going to use the word consensus, actually, that there was a suggestion was really to limit the discretion amongst prosecutors when it comes to referring directly or to refer certain offenses directly to these providers and programs. And that could be at the law enforcement level, that could be at the prosecutorial level, and also at the court level as well.
I'm questioning that because I'm remembering the director from the Lamoille County wanted to keep the discretion for the prosecutor.
Well, and I think that's why I kind of backed off from the word consensus a little bit, is that, you know, there's the other side of it where that discretion is really responsive to the community needs of that county. And so there are arguments to maintain the current system and that discretion so that prosecutors and providers and law enforcement can be responsive to the needs of their jurisdictions. But that was a suggestion, I think, that had some sort of support to a degree, but it was not a consensus.
And he's quiet. The committee is quiet. And the other piece too that I have is to really look at the pre-charge review process and to make it more uniform. And also in the pre-charge arena to it's more of an issue of what services are available across the state, depending where that charge is being brought, what county or what part of the state. In some counties, the person can go directly. There's an open slot in a particular service. It could be a mental health entity, it could be a substance abuse entity, but the services are not equitable across the state for that. There was another requirement that folks suggested was that the judge would send directly to court diversion and have that uniform throughout the state. Those are some of my notes.
Chairman's on the, I guess, sort of accessibility and equitability of services. I'm not sure if there was really a discussion on this point, but it was that these services are provided, you know, throughout the state, but whether or not someone, let's say in Chittenden County or someone in Essex County, while they're provided across the state, the certain provider that they need may not be where they actually are. And so that might be something that the committee tries to tackle as far as a potential stopgap where services are provided, but not necessarily at the location that they're needed. I mean, we live in the age of medicine now and things of that nature. So that might be a point of discussion that the committee undertakes.
Look at me.
No. So I'm looking through my notes here and I'm way back. Testimony from Bobby Sands.
Well, that was way back.
Yeah.
Yeah, that was the,
And one of his first things that I remember him saying was take say 2A, the justice statutes, and move them into Title 13. I don't remember why he said that. Maybe Ben, you can remember.
Well, 2A is the restorative justice policy of the state, and that's also where the CJC statutes reside. On the one hand, I think that suggestion in the Title 13 was to make it clear on the one hand that this is all part of sort of juvenile justice within the criminal justice system. Title 13 are criminal statutes. However, by moving them into the criminal statutes, that in and of itself may send a message that the committee wants to be cognizant of is that the criminal statutes are the criminal statutes. A lot of these restorative justice initiatives and programs are really aimed to keep juveniles out of the criminal justice system.
And adults.
And adults, exactly. And so while that might achieve the goal of sort of consolidating it so it's easier to refer to all the statutes that a court may use and prosecutors may use, it may also send another message as far as the system itself.
I mean, initially our reparative boards and those community boards came from the Commissioner of Corrections. And that's why it's housed in Title 28, because it was really the reparative boards, the thinking back then in the late 90s, mid to late 90s was the community needs to be involved with the offender so the offender can repair the harm. It's their peers in the community that are saying, you created this damage here. How can we move forward? So the initial thinking of these reparative boards, which then developed also into our community justice centers, was the thinking of corrections at that point, because they were looking at people reentering and not having a support system, but also they were seeing a lot of folks coming into the correctional system for nonviolent, low risk to reoffend. And why are we taking up a hard bed for folks that we could have a community system to wrap around services for them? So that was just the beginning of why it was in Title 28, and then it's kind of grown in a hodgepodge way since then.
So it's time to take a look at that growth and.
Well, one thing that there was a little group.
I'm not suggesting we should take a look.
No, but that was the issue. One of the, there were 3 people working on this. Trevor was one, and then I had 2 folks in my committee working on it, thinking that maybe they could just start by rewriting or cleaning up the statutes. And then it was saying that it was more complicated than just cleaning up the statute, that it was really getting into the mechanics of how centers are working, how diversion is working, how the restorative justice system is working. But Trevor, I know you had your hand up. I don't know if you want to add to that.
Yeah, I guess I see a couple things here. One is review of the statutes and clean up the statutes. I think that's something that probably does need to happen. How it happens, I'm not sure. The issue of prosecutorial discretion, I think, is one of the issues that comes to the surface here. And certainly when you start looking at pre-charge and court diversion and things like that, one of the conversations we had in corrections and institutions was to have a study group get together, a broader group of stakeholders. And we just didn't quite get that done the way we wanted to. And Senator Sears and I had conversations about this, and we thought that this was someplace we could go to at least have this conversation. But I guess I would make a recommendation, or at least put a suggestion on the table, that as we're trying to propose some kind of legislative direction here, that we do put that study group into play. Okay? And that we involve the Defender General's office and obviously the funders of the various programs, Attorney General, DOC, DCF, but you also have the state's attorneys, the CDC, Court Diversion Program, and BARGE, and any other groups that we might want to sort of identify that have a role in this process. Yes, it's going to take longer to get to maybe where we want to be with this. I think it's better to do it right than to try to just throw out some legislation here, or maybe fix something here. I mean, one of the things of that the grad student for the professor was talking about that house, so keep adding pieces on, and all of a sudden we're in this place here where it doesn't really function the way it should be functioning. So it's almost like a step back and say, let's take that original concept and idea of a study group. Make sure everyone's involved in the committee of jurisdiction, having a conversation about what this looks like, what are the questions, what are the things that we want to accomplish. And to me, that would be the way I would approach it from a legislative standpoint.
So that working group would not be made up of legislators, would be made up of folks who are actually doing the work.
Yeah.
And then we would set out their charge and a time frame for them to come back with a report. Is that your thinking?
Well, I think it needs to run through the committee's
Jurisdiction.
legislature, let them have those conversations in committee.
In establishing this work group?
Establishing the group. I don't think we should establish it.
Okay. Thoughts?
I guess one of the things, so I think I agree with you, Trevor, about, well, I definitely agree with you about, you know, it needs to be a thoughtful process, because it's, you know, as you were pointing out, Madam Chair, that there was, it had more levels, you know, than just sort of cleaning up statute. And I think that, you know, the charge here was trying to get at what some of those levels are. But even this charge is not inclusive of some of the questions that have arisen during the testimony that we've heard. And my only hesitation is, given our experience today in receiving reports from, you know, various entities that the legislature has asked for, and so setting up another process to be yet disappointed, you know, a year from now that, you know, maybe something hasn't happened, but we should give it the college try, Madam Chair.
Well, I think there was a lot of, and Ben, correct me if I'm wrong, but there seemed to have been quite a bit of work done, but that little subgroup that you were on, that Trevor was there, Mary Morrissey, and Sarah Coffey. It seemed to be quite a bit of work that you three had done with Ben, and then it really came down to that this is really a heavy lift. In order for us to really do this as a legislative body, you would need a legislative committee spending a whole session basically working on this issue to clean up the statutes. At first they thought you could just clean up the statute because it's such a hodgepodge. And then the more you start looking into this, it's like peeling an onion. It's as it got deeper and deeper. And so, wait a minute. And that was the thinking of maybe a task force, a working group, something of the folks involved. Trevor?
Yeah, and having said all of that, I think it might make sense to revisit the idea of maybe having legislators on this, in this work group, right? With the idea that we can pull Ledge Council in because of our participation in the group, help support some of that work. Because I get very concerned about the legal expertise that might be required here and relying on all these different stakeholders and groups to provide that. So I would rethink that.
Yeah, and I know when you folks were talking about who should be part of this work group, when it came down to the CJCs, I mean, all the other entities seem to have a focal person at the helm. There was a person that was the executive director of something. There was a focal, you know, a focus there. But for the community justice centers, they're all independent. So there wasn't one voice speaking for all of them.
I think yeah, the structure is not quite there the same, but I still think there are a handful of individuals that do take a leadership role in that group as well. Would you concur with that?
I think that Trevor's comment about this going through jurisdictional committees is important because I think, you know, one of the things that we learned through experience is that the charge that any task force or group might have is really important in understanding, making sure that we really get that charge accurate in terms of what it is that we're expecting to come out of that. And I think that jurisdictional committees would definitely have something to add to that process. I mean, maybe, you know, maybe what our report back is to those committees, some of whom are represented here, is you know, that the legislation is forming this group and who's on it.
charge.
And the charge, right.
And to keep it short and simple, the charge.
Or as broad as possible, potentially, so that way we don't hamstring people in what they look at, you know? I mean, we tend to sometimes over-prescribe, and then that narrows the focus of what people look at, and when sometimes maybe we need things to be a little bit broader, yeah.
Maxine?
Yeah, I'm wondering if we took the summary that Ben did for us and actually, saw in writing, and if that would be part of the sort of the map or the path to what different committees of jurisdiction could look at based on those, this is what we heard, this is what we're hearing. And then, get recommendations from the committees of jurisdiction. Sort of punting, but sort of balancing, not overstepping or taking too much, taking on too much for us and our expertise, and and recognizing the committees of jurisdiction.
So is what Trevor put on the table as I recommend that the committees of jurisdiction in this work together to establish a working group, a task force to really do a deeper dive, and for them to, the committees of jurisdiction to lay out the charge of this working group and the membership? Dick?
Well, I think we found out how cumbersome the whole system is. And having so many different groups doing similar stuff or not similar stuff. And for me, the main thing that I learned was there is differences between, we have 3 departments of state government: the Attorney General's office, Department of Corrections, Department of Children and Families, with different agendas that these groups have to deal with. And some of the groups deal with all 3, some deal with just one. So I think that's something that ought to be looked at by the committees of jurisdiction in terms of, are there administrative efficiencies that could both help the state agencies work better together as well as the various individual restorative justice programs. But I do think it's worth putting something in about looking at consistency, more geographic consistency. I realize it's going to be a stumbling block with many prosecutors, asking them to be more consistent. But if there's one thing that's frustrating, is to hear in some jurisdictions, certain crimes never even get to court. In other jurisdictions, they go all the way through and may not even be diverted. I think we need to keep that at least alive in some way.
So if we do recommend a working group, that would be one of their charges? Or are you saying, Dick, that we make a recommendation that the respective standing committees need to look at these items?
I think the respective standing committees, I think it would mainly be judiciary, should look at the consistency from district or county to county in terms of the application of restorative justice programming. In terms of state's attorneys and their referrals. I'm not putting it correctly. I think Ben had nicer words than I've got, but I'm stumbling around a little bit. But I do think it's a problem. And, I realize each case is different and there's different situations. But to have people treated, and Representative Grad and I bemoaned this for, our entire time of chairing the 2 Senate and House Judiciary Committees, geographic inconsistencies. And then we have an opportunity here to actually say something about it. Maybe nothing will happen. Maybe there'll be no agreement reached, but at least highlighting the problem would be helpful. And then the other thing I'm meaning is those are the standing committees like institutions, corrections, appropriations. Stuff. Are there administrative efficiencies that could be derived both for the administration as well as the programs?
I have a big note that concerning the senator out of that meeting, and it concerns efficiencies. And I think I'm going to paraphrase you, Senator. Let's put all the money under one department.
Well, I did say that, but I wasn't going that far today because I'm in abstention.
Okay.
But I do think it's worth looking at. I just, I know I've got a great community justice center here in Bennington, and I think the world of the work they do. But it's got to be hard to write, separate grants, deal with 3 separate agencies, and then trying to get after-school grants and other things that she's doing down here in Bennington. It's just fabulous work. But, just.
I don't know where to head with this.
Well, I think we separate, I'm suggesting we separate out two separate.
So that geographic justice, geographic equity within our restorative justice system, where the real focus is on the discretion of our prosecutors, that would be a recommend from our committee that the 2 judiciary committees really grapple with that. Take a look at that.
That's my recommendation. I'd love to hear Representative Brad's thoughts.
No, I agree. Yeah, no, I think that's.
So that would be one of our recommendations. And another one of our recommendations would be for the overall functioning of our community justice centers and our restorative justice to really look at the mechanism and the structure of those and the funding streams. And that there would be a working group or a task force that should be established, but it's the respective standing committees that would determine the makeup of that working group or task force.
Yep.
Is that what I'm hearing? Maxine is thinking.
I know, in terms of the funding sources and one funding source and.
Well, I'm not saying we look at one funding source.
No, but whether there should be one,
Right.
where there are too many.
Or streamline the funding sources.
Yeah. And I was wondering if there's a standing committee or, appropriations with the consultation of another standing committee could look at that without a task force. I don't know.
And that's really what was the incentive of you 3 getting together. A little bit.
Part of it, yeah.
That was part of it.
At least we wanted to explore that, yeah.
Mm-hmm. I feel that's sort of like just restating one of the charges that we have in our, that we had in the Appropriations Act, right? And I guess I also feel like, we actually have heard testimony from, varying members of the community justice centers that they generally don't mind having more than one funding source, that feels like a quote unquote source of stability. If one gets reduced and then you're not, sort of like fighting against the whole tide, you're just having to figure out one piece. So giving them the charge to do something that they've already said that they don't want to do is kind of a weird thing, I think, but that's just my reflection on that.
Yeah, I just want to second what Teresa's saying. I've heard the same comments back from folks in the field that they like the flexibility of the funding sources, even though it may not be the most efficient way to do it necessarily, but the flexibility is there.
It just brings up thinking on justice reinvestment too, trying to figure out where those dollars go.
Well, it sounds like, you know, I mean, I wasn't part of the discussions that were had in the various committees of jurisdiction about this. It seemed like it was more of a concern legislatively than it really was in practice for the people doing the work. And
It was hard to track the money. That was the real instigator. I think it was really hard to track the money and trying to figure out if there was duplicit programming going on. And we're paying for both.
But I feel like we've gotten clarification about that during testimony. I mean, one of the things that I had questions about is how do we track the outcomes? You know, so how do you assign value? You know, is it this contract that achieved the outcomes, or is it this contract that achieved the outcomes? So, you know, I feel like you know, we have 2 or 3 different handouts that seem to all agree, and we've got them in different formats, but that we know how much and we know where the money's coming from and for what section of the centers that are being funded. So it didn't appear to me that there was duplication, at least in the sort of different components of the funded services. Some, yes, some offered all of them, some of them divvied them up. You know, that was a local decision, and, you know, in Vermont, we value local decision making. So I think if I were sitting in a place where I was taking testimony about what are the outcomes, I would have questions more about how are the outcomes attributed to
The funding fund.
That's the question I would really have.
Where are we, folks?
It seems like there was some head nods around the prosecutorial discretion being referred back to the judiciary committees. Does that sound, so that's one positive
That's
thing.
one thing we agreed on. And what about what Trevor put on the table about the respective committees really looking at wanting to establish a task force working group, and they weigh in terms of what the charge is and the makeup? Do we want to do that? One of the charges could be what's the outcome attributed with the funding levels. We're tired, we're worn down.
So what is sort of for me, what am I really going to be drafting here? Is this a recommendation? Is this legislation? What's the committee thinking as far as what form this is going to take?
Well, in terms of the geographic equity or justice of our restorative justice system, I'm going to look to Maxine. Is that something that could be a short form bill that gets drafted for both committees? Or is that already in the hopper?
I think the one paragraph that Ben wrote is fine.
What's that one paragraph, Ben?
In the current charge of this group?
No. There, you started out reading that one of the suggestions was to look at the geographic disparities. Right?
Right, yeah, so incorporating that into.
Piece of legislation?
Well, the problem is the Senate can't do a short-term bill.
Right.
It could be a recommendation to the committee.
To the committee. So we'd make a recommendation to the 2 chairs.
Yeah, that's fine.
Okay.
Yeah, I don't want Ben to draft a whole big bill, and
Yeah.
I just think the committees could probably jointly hold a hearing just to hear various thoughts about it. I'm sure the prosecutors and some judges are disagreeing, but is there a way for judges to or defense bar, whoever gets, a lot of these crimes, person doesn't even get a defender.
So I'm just going to lay this on the table. Should we, I know we're not required to submit a report. We used to submit a report back in the old days, but now we're not required to. Is this something that we should do in terms of a report or just a recommendation to the chairs of the respective committees? Because I'm seeing nodding in terms of recommendation to the respective chairs.
Yeah.
Okay.
Yeah.
So the other piece that we've talked about is establishing that working group or task force, that we'd like that to be established, but it's up to the respective committees to look at the possible makeup of that and what their charge would be. So those respective committees would be judiciary, I would think appropriations committee,
Institution.
and institutions and corrections. Well, I don't know about on your end, Dick, if institutions committee is even connected to this.
Currently, they're not.
They're not.
So they wouldn't be involved.
So it'd be Senate Judiciary, Senate Approps.
Yep. We don't mind having it 5 members. I mean, 5 committees.
5 committees. And then on the House side, it would be Approps, Judiciary, and Corrections and Institute.
Yeah, as long as you're both across the hall from each other, not too much of a impediment.
Well, I hope we stay there.
It was very handy to beat both of you in the hallway to talk about it.
Right around the corner. Does that make sense, Ben?
I'm still trying to follow it, to be quite honest. I'm just trying to think of how this is going to work, like practically. So we're.
It's going to work like the community justice centers.
Be a conglomerate of programming and yeah. So we have the working group aspect, but we need to think about when is this working group going to meet?
Well, no, it's establishing, it's starting to establish, what that working group needs to look like will come from the standing committees.
Okay.
Those be legislation.
Committees will need to establish the working group.
So do you get that information to the standing committees through a recommendation, or do you have to have legislation? Do you have to have a bill?
Basically like,
No,
just recommendation.
Well, I was going to say, this is almost like a bill request. I feel like.
Sounds good.
Yeah.
Do a committee bill, really. It sounds like it, right?
Yeah, but we don't know what we're going to do for a charge, and we don't know who's going to be on the working group.
Be a short form bill.
But they don't do short form in the Senate.
Oh,
Start in the House.
Start it in the House.
Fine by me. And Senator Hooker is probably okay with it.
I'm fine with it.
You know, maybe that's what we're doing, a short form bill on establishing a task force or a working group, whatever we want to say, on, and the charge is looking at our restorative justice system,
Overall function.
overall function of our restorative justice system.
it's right.
Statutes.
Yeah.
And just do a short form bill
Funding sources, right?
and funding sources. Keep it simple.
You actually take up those short form bills?
Yeah, we do.
Yes, we do.
We do.
Oh, okay.
And so would that encompass everything that was sort of listed before?
But not the geographic justice.
Right.
That's a separate request from our committee to the 2 chairs of judicial.
Just a memo.
It's just a memo to them. That's a separate,
So that's just essentially a request to the committee chairs to look at the issue.
chairs to take a look at that issue in this next session. So that would be a memo
Okay.
to the 2 chairs coming from this committee. And then the establishing a working group task force to address the restorative justice system. And we laid out, 3 things? there?
Yeah, the mechanism, structure, and funding of the restorative justice system, sort of how are outcomes of that programming attributed to the funding itself, and then I guess essentially a recommendation to the judiciary committees concerning prosecutorial discretion and geographic consistency, but that was sort of rolled into those three, and then there's the separate memo that's sort of concerning the same issue to the chairs. So do we want to break anything out or eliminate
I
any?
would take out the geographic justice thing on the working group. So we're involved, we're interested in that working group in terms of the structure of the restorative justice system, the outcomes attributed to the funding levels, and
Current statutory language?
current statutory language. Update of current statutory language. That working group would look at.
Yeah, and do you want statutory language or statutory organization? Because those are kind of two different things. Just hearing the discussion today of the committee is that.
Looking at current statute, updating the current statutes.
Yeah, that could be because organization is the one thing where, that kind of goes back to the suggestion that Bobby Sands had about moving it to one title or another, but looking at the language itself would be different, and that could affect funding sources and things like that, where it seems like there was a real debate over the merit of doing that. So do you want to kind of keep it broader and it could just be review of the statutes?
Current statute structure of the current statutes. That makes sense to you folks? Down on the
That's a loaded question, Alice.
boots on the ground,
Really want an answer?
going down the wrong path.
I mean,
You just identify yourself, Jill.
huh?
Just identify yourself.
I'm Jill Evans, I'm the director of the Essex Community Justice Center. When I hear you go back to what the original charges of this committee were, which were to look at the streamlining and also the concern that there might be duplication of service or that kind of thing, I agree with Representative Wood that I mean, our group has really come to a place where we find like we're in a lot of agreement, and when we debriefed the last testimony that was given, we walked away saying, yeah, I feel like we've really shown through our testimony and with the documents that we've prepared that there is no duplication of service, that every service that's considered a restorative program that's funded by the state is available in every community, and we all agree with you. The issue is that there is prosecutorial discretion that impacts who has access to those services and who doesn't. And one of our recommendations had been, as testified in the last hearing, that probably should be looked at further. I mean, I'm not a legislator, I don't know what a legislator lane is and otherwise, but like, maybe look at the data first. Like, I find that we're talking about these things and they're like, you don't really know how many are we talking about? Is that like 2 in Lamoille County and 7 in Broward? Is that as concerning as if it was a different set of numbers? I don't know. So I think about that, like, where is the stuff that's really the data? I get a little concerned and feel like maybe we haven't done our job or missed the mark or something when I keep hearing things like that it's a cumbersome process and that kind of thing. One of the things that we talked about at our last meeting was this is not unlike looking at the continuum of care for early childhood. There is not a statewide system that was put in place that, as Steve would argue, has state employees providing it, who are getting benefits, and there's all kinds of efficiencies and standards and consistency in that model. I mean, the reason the community justice centers came about is because the local communities in the Doble study said, we want to be involved. And so this has been a community effort. And I feel like with parent-child centers, Head Start, and reach out programs, they look a little different in every community, and there are reasons why they look that way. But the fact that they look differently doesn't mean that they're not functioning or that they're not effective or not producing. And I apologize, my 14-month-old grandson gives me every illness he catches at daycare. I was not able to testify at the last one, but, you know, there are reasons why Chittenden County, why it works as a still municipality-based program that has geographic difference. And there's a lot, you know, there's reasons for a lot of stuff. So partly I feel like, oh God, are we ordering like another look at what we thought we were trying to prepare and testify to you to make it clear. And we do agree that the prosecutorial discretion, and I would add the caveat that given the current times, that along with those issues of equity for access to the services also would be racial and economic equity that I think we all share anecdotal concerns. That people of color and low income people might not be accessing the services like other groups of people. So those are the things that I think about.
I mean, I think you've been very helpful, and I don't want you to have the impression we didn't pay attention to your testimony. I think what's difficult for a committee like this, where we meet once a month, once every 6 weeks, you lose that thread.
Yeah.
And you can't do that deep dive as a standing committee. So sometimes the continuity of testimony and the information gets lost. And so that's what I think is happening, because we have so many balls in the air right now in terms of issues that this committee is dealing with. So we just touched the surface. And the language that is being required of us here was really the language for that initial working group that people were thinking about, where that would be your focus and you just look at that. You know, is it redundant to trying to establish a working group to go forward? Or do we just keep it as a recommendation to the Judiciary Committee for Geographic Justice within our prosecutorial arena and make sure there's economic and racial equity as well? And just leave it at that.
My name is Willa Farrell. I work in the Attorney General's Office with Court Diversion and Pretrial Services. And to build off what Jill said, and I think this committee is really named around prosecutorial discretion, is when you look at all the services that our three departments fund, the area where that is of most interest or most prevalent is pre-charge and court diversion. I mean, that's really, I think, the nexus point. And in terms of, I appreciated this discussion between you, Representative Evans, and Representative Wood about like the scope of any work group. And I think our subcommittee work group of our providers and funders was really thinking that further work, it could be helpful to really focus on one aspect to make this feel doable and something that's accomplishable within a certain time period for us. And I think that area of prosecutorial discretion is the most relevant one, because that's really the issue, I think, that Senator Sears alluded to one of the stories last time we met about the woman who stole from the grocery store and how that can play out. And it's really that front end decision making. The other comment I'd like to make around looking at statutes is the statutes that govern the services that our office funds are all programmatic and are very, and both judiciary committees often look at what's something in court diversion or pretrial services or the underage possession programs. And so I feel like if I think about our statutes that govern the work that we fund, they're very programmatic and specific about people's rights and what the process is. And then without going too much outside of my lane, looking at the sheet that we provided, the sort of reference, the statutes, so there's programmatic statutes, but then there are also organizational statutes, and those are irrelevant, frankly, in our world. We fund for services, we don't fund an organization. And so if you want to look at statutes, it might be helpful to figure out, do we want to look at the statutes governing a program or governing structures? which harkens back to one of our original points we've been making about restorative justice isn't a program and organization, it's an approach, it's a way of doing work. Community justice centers are an organization. Most of them they all receive money from DOC, some of them receive money from AGOs, some receive money from DCF. And so just clarity around which statutes you want to look at, I think could be helpful.
Is your group going to keep meeting?
Agreed to meet at least 3 more times, just based on what we knew as of the last testimony that was given, and had talked about like actually putting data to the concept of pre-charge and court diversion referrals.
So I wonder if instead of doing a working group, I wonder if your group that you're working on, that we make a recommendation that you come back to the respective standing committees with a summary of your work and any recommendations you may have, such as cleaning up the statutes, but then you look at a specific piece which deals with maybe a structure or deals with a program. I'm wondering if that's the way to go, that we make a recommendation that your group, whatever title you want to use, has been working on this, and they're going to have a few more meetings, and to come back to the respective committees, which would be appropriations, judiciary committees, and corrections and institutions committee, with the work that you've done and any recommendations you might have. I wonder if that's the way, the approach, instead of setting up a working group.
I think the short form idea might accomplish all of that. If we were to shore up the language, maybe focusing on specific issues like Jill and Willa had mentioned, then they and their group could probably become witnesses whenever that short form is taken up to then discuss those various aspects. The practical question in my mind is that, there's the short form, and then there's committees discussing the recommendation, to that would go to these committees. Well, what would be the mechanism really to bring their group in pursuant to that recommendation? I think there probably has to be a bill, be it a committee bill, be it a short form bill, or something to be the impetus for that.
Mm-hmm. Thoughts? Go ahead, Trevor, and then Max.
Yeah, I don't think there has to be a bill for committee chair to say, I want to talk to somebody. So I don't think you have to have a piece of legislation in front of you.
Okay.
Maxine?
So, well, I really appreciate when you said that the community justice is an approach. And so I'll be popular, but it brings me back to the starting point of prosecutorial discretion. And, if we, say this is an approach and then we support it, and what does it look like to truly have that approach in our justice system? And that's where we ask questions about, discretion and.
So why don't you work up a little bit for a short form bill, and we can talk about it December a little bit. You're going to probably be meeting between now and our December meeting, and then we can go from there. And then you do have a drafting request, or not a drafting request, a memo to the chairs of both judiciary committees, so we can go over that memo at our December meeting. Then we decide on the 1.6 million. we're gonna reach out, we're not gonna reach out to the folks, right? Didn't we decide that, not to reach out to the folks?
I don't think there was a decision made on that portion.
I thought we were tending to say yes, but not promising them any money.
Right. It was.
More information
More
that might
information.
inform the appropriations process.
So then the issue with the transitional housing is we get the list from DOC.
Depends how deep you want to stick your toe into the water.
Not very deep.
Yeah.
And this
Anytime.
is together and for.
Chris, every time you ask people for their opinion on their funding and stuff like that, they're expecting money.
Well, no, I know. I was just reflecting what I thought, how we had
Yeah,
left.
yeah.
We didn't come to a final conclusion, but I think that's where we had left.
And I think Representative Wood, you're right. It was more of an information request. My question as far as to who to address it to is that, and not to bring Stephanie back in, but my understanding for JR2 funding, really the only entities that receive it on a broad level are DOC and the Vermont Network. And as far as the transitional housing partners, I believe that they are funded through, is it a grant system?
Through DOC.
And so that just to kind of keep that in mind, because it would be helpful for me when I draft a letter into whom this goes to. Is the committee really requesting information from these various entities that ultimately answer to DOC when it comes to the grants that they receive? Stephanie, correct me if I'm wrong.
The budget process around anything, when we appropriate money, we grant out to any entity, whether it's a nonprofit or another service provider, we appropriate that money to a department. That does not mean that those service providers do not come to the committee outside of the department. So the request for information, the form that would take to the network to, I don't know what the overall entity is for the housing, but you could look at that, the transitional housing, the network, the mental health, the Representative Wood just left, there was the issue of the substance abuse treatment. So you could reach out to the advocacy groups that we know of that represent those groups and ask for information, or you could ask the standing committees with this remaining funding, this is what we want you to look at, which is something else you discussed as well, like to give direction to the appropriations committee about the remaining 1.7 million.
1.6. So.
And apart from who it's addressed to, the substance of the memo would be basically information about their immediate needs for fiscal year 23 and 24 to meet JR2 goals. Was sort of
How much of the current appropriation they've expended? Current. So Derek, of transitional housing, there's 6.35 million. It's in your budget. You must have a list where that 6.35 million went to.
Absolutely, that's the public listing that I referenced, that the individual Feldman followed up and provided that. That is a listing of 15 different community-based agencies that comprise effectively the totality of that $6.3 million, which I understand to be general fund. Is our base, and it has been our base budget for our transitional housing grant program.
Some of that got expanded through JR2 investments.
You do that, I believe that 6.3 is now bifurcated. You see about 3.7, 3.8 in the JR2 line, and the remaining amount is in the correctional service line.
that's the way the funding is for the totality of transitional housing. And so I don't know, when we separated out the line, and we asked to separate out the line for JR2, when we created the line just this year in the budget, the amount that corrections gave us that was JR2 related was that $3.7 million number. And so in terms of transitional housing, it is a contract arrangement between DOC and these service providers. And so DOC may be the appropriate people to hear from in December in terms of the immediate needs for transitional housing. I don't know if that's an option better suited to understand the ask in total for transitional housing as opposed to the individual service providers.
So you're saying go to the contract?
I'm saying that it's a contract arrangement between DOC contracts with
Right.
housing providers. It's not just, I mean, it's a grant form potentially in some instances, but because DOC has the picture of all of them, you may want to start with DOC's understanding of what the needs are across the universe they have contracts with for transitional housing.
So go to DOC instead of the individual providers that you fund through the grants.
Yeah.
That would be fine with me.
Yeah.
So you do DOC and you do the network.
Yes.
And then, I don't know, do DMH as well.
Hey,
Would.
Yeah. I can email her.
are you clear as mud on this?
Well, I think I have enough to draft the memo, what you're asking for. I think, maybe we can work together as far as who we're sending it to, who the committee's sending
I think we are deciding the network and DOC.
network and DOC. I do know Representative Wood did mention,
The substance.
was it DMH?
Well, DMH is separate. That's a separate,
Right.
400,000 is not part of this.
The mental health aspect, so.
Yeah, but it's the substance abuse.
The substance abuse there's substance abuse treatment that's in DOC for incarcerated folks, but once they're outside, substance abuse treatment is primarily provided through the ADAP, the Medicaid and the programs through the Department of Health. I don't know that the DOC provides substance.
So it'd be set up like DMH.
Yeah, and so you might want to, I don't know if you want to hear in December from DMH and Department of Health on substance abuse.
But that could be one of our recommendations, that if look at substance abuse or substance use on the outside, that maybe we need to vet where those dollars are funneled through. If it's funneled through ADAP, but then you're going to get back into the situation where you've got JR2 dollars that are going out and you're scattering it that you can't keep track of. Because right now we have 400,000 that's out there that's not part of the justice reinvestment line in DOC. So we have 400,000 that's gone to DMH to provide mental health services for folks who are reentering. That's not part of the line item that got established for JR2. Because the JR2 line item is in the corrections part of the budget. So once you start siphoning off another amount for substance abuse treatment, you're funding ADAP. Unless you specifically say turning points, recovery centers.
I don't want to complicate it.
I don't
But actually
want
put all the money in DOC and transfer it to another department that's complicated on an administrative level, especially if something in mental health or substance abuse is drawing Medicaid dollars, you start to grade very quickly. And so, it's just a way of simplification versus accomplishing your goals of tracking.
What's a way of simplification?
I mean, it's a way, you're weighing the balance between, do I make it simple or do I make it simple from an administrative point of view, but complicated from a tracking point of view, weighing that balance. And
how you structure where the funding starts and then how you track it.
Tried to make it clear and we made it worse, maybe. So if you could send that memo, and I would share it as well with the committee. I don't want to send something out like this on behalf of the committee without committee members seeing it. But it would be going to the network and DOC.
Okay.
Sharon, if I may seek some clarification, I believe I heard earlier reference to the committee's interest in getting a better understanding of the needs of the transitional housing providers as well as the community justice centers. I didn't hear that just referenced. Is that something that DOC should anticipate coming prepared to also speak to?
Well, what we've got right now in our base funding is 2.9 million plus for community justice grants, 3.7 million plus for transitional housing. And then we've got the domestic violence program. That's our 3 areas. Might as well include the community justice centers in that info. But how much of the JR2 money went to the community justice centers?
Except for the COLA and $417,000.
Yeah, that was the COLA. Yeah, that was the one-time
DEI increase per site.
Right.
For this year.
So of that 2.9 million that's here in this line item, only 417 is from justice for investment. Because we did that in the appropriations piece because of the cost of living. That was a one-time thing.
I believe it was 417 that was supposed to go to the CJCs, but 100,000 is going towards the market study, the internal. I think we only ended up getting.
Oh, Joel, thank you, I believe you're right, I think we had a total of 417 one-time monies and approximately, there was the COLAs that represented about 205,000 and then the 85,000 or so in the DEI, so about 300,000 went to the CJCs if I stand corrected.
And what market study?
But
I'm trying to remember what market study.
we've contracted to do some of our own public market about what constituents want out of the future services and structure of the DOC's community justice funds. Obviously, those are the funds that we have direct responsibility. I believe that the money we're talking about now is above and over
So what
that
is the
2.9.
Yes.
2.9 is the base in FY '23. The 400 and its component pieces was the one-time money from last year that got applied. It's not in the base. Because
It's not in the 2.9.
It's not, it's over and above that.
I am so glad I'm not in a pros. Are you as confused as we are?
I think it's still the Vermont Network and DOC. Okay.
Just figure out that memo. And,
I'll circulate it.
yeah, and we'll have the whole committee weigh in.
I would just also respectfully submit that while the money that's going towards this public market research we're doing doesn't directly get distributed to the CJCs, the intent behind it, as Commissioner Demel spoke to, is to in fact benefit the totality of these services in the centers by having a participatory process that looks ahead to how they can be responsive to the needs of their community, what's the current scope of work, what might the future scope of work be. So from DOC's institutional perspective, it's still in fact money that's supporting the CJC, it's just not showing up in individual budgets.
Okay. Anything else? It's 4:00. Anything else? Okay. Thank you all.
Thank you.
Dick?
Well, I just wanted to thank you all for the meeting today, and I'm glad I wasn't in Montpelier because I wouldn't get home in time to relieve my aides.
Oh, you're home and that's a safe place to be. And good luck.
Yeah. Thank you. We'll see.
Hang in there. That's all we can do. Anything else?
When I'd like to speak to you for a minute when you go off YouTube, Alice.
Okay, sounds great. Okay, thank you, folks on YouTube, and our next meeting's in December 12th.
Do you want the vote? Ally?
Yeah, that would be great. I'll take care of that.
Thank you, Ben.
Thank you, Julie.